Welcome back to the Law and Crime Network, everybody. This is Jesse Weber. Well, now they're in a mid-morning break in this case, in the Cloud9 murder case, the case of Laquan Barrow, Michael Smith, and Gary King. You heard the prosecution's opening argument. Well, we heard your comments about what you thought. Some thought it was a little slow. Some thought that it was a good points here and there. But now let's talk about break it down exactly what was said. And joining me today is criminal defense attorney Vinoo Varghese. Vinoo, let's talk a little bit about what was presented in the prosecution's closing argument. Do you think it was strong?
No.
Well, tell me what you really feel.
Look, I am a former prosecutor, and as a prosecutor, what you want to do is capture the emotion. He obviously has to prove the elements of the crime, and he's listing them. But at one point, he compared it to a BLT, and then didn't explain what that was, why he did that. And if you're trivializing, or by doing that, he trivialized his position. You know, at a certain point, as a prosecutor, you've got to keep it simple, stupid, right? And so you have a case. Yeah. You have a case here with a dead body. You have multiple people who identified at least one of the defendants as the main shooter. You've got all this language. Now, at certain points, he talked about it. He did, and he got a little more amped up as we got closer to this break. But you know, the first thing he's got to do is, the first problem he had was organization. He should have outlined his points and said, this is what I'm going to talk about first, this is what I'm going to talk about second, this is what I'm going to talk about third, and then go back and then keep the jurors in the loop. He didn't do that.
Engaged. They didn't feel engaged. I mean, I think towards the end, when he started breaking down why each of the witnesses put forward by the defense was not credible, that was strong. For example, when the videotape footage shows where one witness said, I didn't see the police that night, and the police are literally walking right by them, how do you disprove that? When you have a witness say that they didn't see Mr. Smith at the club, and then you have a video of surveillance footage showing or that they're interacting, that's strong. I think he kind of maybe got a little bit lost in the weeds when, well, particularly I think when, correct me if I'm wrong, when a prosecution has to submit a weakness in their case, it's not great. Basically showing about the lack of DNA, the lack of fingerprints. I mean, in a way, it's good. They're not hiding that from the jury, but it does show the weakness in their case. Am I right?
He dealt with that too early on. And in fact, his slide, or the picture he had up, said evidence, and he had DNA and fingerprints. Well, no, it actually wasn't evidence in his case. It was a lack of evidence. He shouldn't have put anything up there, and he just talked about it. And he should have minimized that somewhere in the middle, not early on like he did. And then go back to why it's not relevant, or why it's not important here, and then here, look, and then talk about what the defense is going to say. And so he would have said something along the lines of, look, you're going to hear, they're going to jump up and down and talk to us about lack of DNA. Folks, it doesn't matter. Mm-hmm. It's a smokescreen, and here's why.
Yeah. Well, again, the defense will be putting on their arguments probably after this break. We heard a little bit, he was talking about the difference between second-degree murder and manslaughter, to going over the verdict form. Do you think that it is possible for even at least one of these defendants that the jury might find that there is no second-degree murder but a manslaughter charge?
It's possible. And
what would make them think that?
There may be, for some reason, sympathy on the part of the jurors towards one of the defendants. And every juror knows, and they've been told that this is the higher charge. So they're going to be like, well, you know, in a second degree, because no matter what the judge tells them, you know they're Googling it. You know that when they've gone home, they've Googled
really?
it. And
that lack of faith in our jury system, huh?
I'm just telling you, there have been too many examples of people getting caught and tweeting about it. And those are the people who get caught, right? So you know they're Googling it, so they're going to be like, man, this guy's going to face so many years in jail if we convict him of second degree. Mm-hmm. He's a young kid, you know, he's a jerk. Let's give him manslaughter. That could be the compromise verdict.
I want to talk about reasonable doubt before we go into a clip and talk about some of the other cases today. Reasonable doubt, right? Break it down for our viewers here. Do you sense a reasonable doubt in terms of Gary King? I'm not talking about Barrow, not talking about Smith. Gary King has his own separate jury. You see him right there. I don't find the level of compelling evidence against him as I do against Barrow and Smith. What do you think?
I'd agree with you. And as we talked about earlier in the segment, if his lawyer, what his lawyer should do, in my opinion, is get up there and put out a chart on the big screen. Because you know the prosecutor's already gone on the big screen with his chart. You can get a better chart and go, reasonable doubt. And here's what's reasonable. You know, it's a doubt for which you can attach a reason. It's an honest doubt. These are the instructions the jury is going to get. And he's going to say to the jury, or he should say to the jury, that no matter what you look at here, and no matter the fact of what you feel that this young girl is dead, it's a tragedy, but there just isn't enough evidence to convict my client beyond a reasonable doubt. That's what he should be saying. And I think you're right.
I think one of the people that was tying King was the victim, Nathaniel Kendrick. And he basically at first didn't identify Smith and King as shooters, and then later on did to do so. He originally said that Barrow was the shooter. But the question was, he was shot. Maybe it's not fair to judge what this surviving victim first said to police and then later on. But then it becomes difficult for the jury to decide, well, aren't people allowed to change their stories in terms of what they saw, what they didn't see? That's what this whole case is about. People who provide one account to police in depositions, and then they're providing now. You heard the prosecutor talking about it now. Which do you believe? A statement that was made a few days after the shooting, or a statement made 2 years later? I mean, what is a jury supposed to do?
I think the reasonable view is that something closer in time to the actual crime is what should take precedence, what should be believed. The police can solve a lot of problems here if they would just videotape interviews with their witness, right? If they had done that, then there wouldn't be a problem of what he said, because later on witnesses will come back and say, I didn't say that. And then depending on the jurisdiction you're in, they may be more police friendly, they may be more defendant friendly. If cops just videotaped interviews, not only with defendants, but with witnesses, you'd solve a lot of these issues. Because the jury can then see how this person did while not in front of a jury.
Yeah, what do you expect the defense to do? I believe Mr. Barrow's defense attorney is going to start first. Mr. Gorley, what do you expect?
I expect him to come out and highlight the strengths of his case, like the witness who said that he didn't feel a gun. Look, he's got to go with what he's got, right? And he put on a case. So he's got to do that. Then he's got to highlight what I talked about earlier was the CSI effect, right? Talk about it. Folks, they're giving you easy explanations for this problem here. There is no DNA. There's gunshot residue on one hand, but not on the other. There's inconsistencies, and just keep hammering that home. If he does that, his client could walk.
So we keep hearing this testimony from witnesses that were brought out by the defense, and we'll hear about probably this testimony brought out. I want to play quickly the testimony from Herbert Welcome. This was from yesterday. This is Michael Smith's cousin. Again, so many of the witnesses brought out by the defense are either somehow related to the defendants or are friends with the defendants. Issue of credibility, folks. That's what it is. Both sides. This is a whole issue of credibility. Which witnesses will the jury believe? Here is the testimony of Herbert Welcome. And when you come back, before hopefully we go to our live feed, we might be able to tease out another case that we're talking about today. Take a look at Herbert Welcome.